Yes, call please forward.
Item number 1, ask for the state leadership.
In the order, there's what is the Jalpaiguri police station? It will be a Kotwali police station. We are informed that this has been reflected from your petition.
I don't see.
No, just let us know.
Yes, ma'am. Yes.
We are informed that due to a typographical error in the application filed by the petitioner, the same has been reflected in our order, wherein the name of the police station has wrongly been mentioned as Joyga. Has been mentioned as Joyga PS case number 331 of 22 instead of
Kotwali police station.
Kotwali police station case number 331 of 22. The mistake is obvious as can be seen from a copy of the FIR. And next will be application. We therefore direct that Jayagam PS case number 331 of 22 be read as Kotwali PS case number 331 of 22 in the order dated 17/12/2024. So the order stands modified to this extent.
Item number 2, Rashid, I don't want to ask for the state. I called the IO regarding the man of Bhutan. Interim bail was granted.
Petition counsel is not here.
Earlier, official, my lord, they are taking time for today. Yesterday, not today, and not to satisfy, because my lord asked them, the man of Bhutan, what is the ensure that after releasing bail, he will not turn up. So, in that respect, your lordships, the earlier petitioner, coordinate page, give a direction. After releasing in the order, paragraph 5, your lordship, they have stated that after getting bail, they could not remain in jurisdictional court.
And once in a week they have.
Once in a week, yes. But as per IO said, they didn't come and not. I think he will not give bail.
They have not visited the
IO.
Then why he has kept mum over this? Now when we are calling him, he's telling us
Yes,
he is not obliged to inform that there is a breach of the terms and conditions. If it is communicated to him, what is he doing?
Got bail. He said he did not got bail released. Should not be released.
It has not been released.
Not released. Huh? It is confirmed.
Oh, this man knows nothing. What is this? You're absent, child. You come to the court so casually. He doesn't know anything. What's the point in having him here? He told you to inform him that he should come ready on the occasion. Doesn't know
Even
anything.
I personally.
He looks puzzled, lost. He doesn't know anything. You're asking.
Cancellation.
Actually, the bail was granted by your coordinator due to charge was not claimed. That is they have got.
We are not
But-
on that.
Yes, lordship.
He asked him to come here for a purpose. He says they are not reporting to the police officer. If they are not, what has he done?
Oh, after getting bail, he didn't turn up. So as
So
per order.
why he's sitting idle? That we want to know.
Bail হয়েছে বলছি।
Ask him why he's not diligent. He's lacking in diligence. Should we record something against?
বেল নিয়েছে আপনার সাথে দেখা করতে ডাইরেকশন ছিল তাহলে আপনার ক্যান্সেলেশন প্রেয়ার করবেন
Dealing with a accused under NDPS, a foreign national, and this is the way he's been doing things. Look at him, he looks lost, he doesn't know anything.
violations and
What violation? How do we know,
Yes,
sir?
Your Lordship.
Please try to
yes,
understand why we are so
Your Lordship, I understand.
anxious. This is the way. Direct the SP to proceed against him. Ask him to submit a report.
Lordship.
Why he didn't inform till now? He is the IO or absent.
Yes, I
The IO is present in court.
Thank you.
Stop. Surprising. A unique situation. He is supposed to enforce the law. He doesn't know anything. And the accused is an accused under NDPS, a foreign national. Just look at the situation, why we are anxious. Is this expected? We are informed by the learned, we are informed by the IU. Plus, we will not tolerate.
Not
Item number 3.
None of yes. Not. In any case, if nobody's appearing, it will not.
Item number 4.
Cases under section 21C and 29. Nothing has been recovered from the position of the petitioner. His name has been transferred from the mouth of the court.
Where's the FIR? Let's send the mail the next street.
Page 50.
Caesar list is also there, my lord. Actually, the
How many persons were there?
3 persons. 3 persons. From one person, namely Samrat Acharya, 49 bottles of cough syrup has been recovered, 49 bottles. And from mouth of the Samrat Acharya, Animesh Ishwar and another person name has been transferred.
He has named 2 other persons, that they are associates of the procured from them. What has he said?
Not procured from them.
That is the allegation, but there is no recovery. You have any instruction regarding their antecedents?
No.
Someone from my knowledge, there is no antecedent, and my she is the resident of the same police station.
She
He, Animesh Ishwar.
and is in jail since.
Jails minor. 69.
41 bottles. 49 bottles of cough syrup within bracket substance codeine phosphate has been recovered from one Samrat Acharya. So he has stated regarding procuring the same from the petitioner and one other person. Is submitted by the learned counsel for the petitioner that even as per allegations in the FIR, there is no recovery of any contraband from the petitioner. So his implication is by a co-accused in police custody, having no sanctity in the eyes of law. These circumstances therefore are sufficient to submit that no case is made out against the petitioner. We have thus given the learned state counsel an opportunity. Stop, it is submitted that the petitioner has been named as being the person from whom the procurement has been made. Considering the rival submissions, we are inclined to accept the submission advance on behalf of the petitioner's counsel for lifting the bar under section 57 of the NDPS Act in favor of the petitioner. We also find that petitioner has no antecedents as per the uncontroverted submission of the learned counsel for the petitioner. That being the fact, we are also in a position to consider the propensity of the petitioner favorable to lifting of the bar under section 37.
Because one in just my objection is, madam, before as 37 has been reverted, madam, just I raise an
Objection to?
the bill.
We have already.
Madam,
That is lifting the bar under section 37 for the limited purpose of grant of bail. We have said that you have opposed that he has been named as being person from whom the procurement has been.
No. Let's make it 42.
Item number 5. I am not today. I don't think I'm not today.
Not to.
6.
We'll do it.
On the basis of statement of poet.
Item number 7.
Yes.
Minute Kumar Shakya. NDPS. All of us on the banner. All of them was not the yearly. What is yearly? Monday is the last day.
Not legally. Then we are not passing it further, just.
Item number 8.
Yes.
It was last week, my lord, was this last for the dates. So the record where on the written putting my lord.
This is the matter where one of the petitioner, he previously has granted bail and he has come up to restoration matter on the last of the.
So this is the earlier application.
Yes, yes.
This is the earlier
This
application.
is the earlier, which was later on restored.
It has been started.
646, we have one copy, you have given us one.
Yes.
In view of certain order passed in CRM within bracket DB 646 of 2024.
Item number 9. Item number 9. Item number 10. Item number 9, Rashid. For last 3 days not appear, even today, tomorrow I inform, inform me that he has no contact with his client.
But today will be.
Yes. Item number 10.
Extended hearing was done in this matter. Petitioner is 21 years. Last relationship. And thereafter 23 years.
On the last occasion, my lord has sought instruction from the petitioner what he intends to do.
Yes,
Do you remember that?
yes, his lordship's query.
Yes, lordship query. I contacted with my client and they also specific question, will marry, if another 498 or any other dispute or and become relationship now become short. And they are also confusing. If we marry, then another dispute will come. What will be the family life and all these queries came to me. Family member of the petitioner. This is now. No further reason. This is the problem. They have put the question that how I can told them nothing will happen in future.
That nobody can say.
Yes, madam. This is the problem. This is my.
Nobody on the earth can say that tomorrow nothing. Only someone above can say.
Submitted both were major, but 90 days in cast. I cooperated with the trial. Both were major, madam. 376 did not lie. 64 now. And just some. Page 37 is the statement.
What did she say? What has she said?
She has submitted the case.
Item number 11.
Madam, kindly comes to the observation of the learned Calcutta, the last page of the worksheet. In view of the observation of this honorable court, the learned Calcutta has rejected our clear public. And it's the observation, it reflects on the page number 11 of your.
Page 11. He's an official.
Now the lordship comes to the another observation of this honorable court while granting bail to the another accused person on the same.
No, you are an official or you are not?
No, I'm not. We are the law agents. Calcutta is not trying his mind while actually getting the bail application. He's been influenced by the order of this one, where it is not been stated that you should follow my. We have surrendered. It is not a fact that the prosecution has arrested us. We voluntarily surrendered before the London trial. And we are in custody for more than 45 hours as of today. And the Prevention of Corruption Act does not lie upon it.
That is a debatable issue.
That's
Merely because you are not a government official, that does not mean you will escape the provisions of the PC Act.
it's a matter of opinion.
That is, cannot be said at this stage.
Lordship, earlier occasions, it is clear that they are preparing one forced deed, the who already died long before.
So these are rising out of the same incident.
Same incident. One is the
This one is also rising out of the same.
same.
So apart from the ADSR, there were two other people. So he's one of them and he's the other one.
ADSR was not made a FIR in the accused person. It was by the honorable this work has asked the prosecution to make him a partner.
So thereafter, he has also been.
Yes, that question is going on, your lordship. That I have already made it clear before one official of the IO conducted against the ADSR. For that, they have already made a prayer before the concerned authority. and they are waiting for the granting order, and thereafter it will be
They
started.
are waiting for the sanction. Under
Yes.
97 of the Code of Criminal Procedure 97.
And they
The
are
sanction
also
of this will be coming.
persons, they are involved with the.
So in so far as this petition is concerned, is
One is the identifier, also dead person's identifier, and another is the deed writer.
what is the role assigned to him, this person?
This
Oh,
person.
there are three.
We have four. This application comes with four.
Who are these four persons?
They are the law clerks.
All four.
All.
Only two
One is
clerks are
deed
signed.
writer.
Petitioner number 2 is the lead factor.
Who is the deed writer?
Right.
What you saying all are, can't be.
Tuhi Odhikari deed
Only
writer.
two have signed on the document, so there must be only two law clerks.
May I? Tuhi Odhikari deed writer, your lordship.
Sorry?
Tuhi Odhikari,
Huh.
first, number one.
He is the deed writer.
Second one, Anil Roy, identify witness of the deed.
Yes, he is identified.
And another, Mahibul Haq, typist of Tuhin Odhikari. And he made also witness in the deed. And he has been arrested on 6th November 24.
And Shyam Sundar Roy?
And Sam Sundar, clerk of Tuhin Odhikari.
Petitioner number 3 was arrested and others they
petitioner-
have surrendered.
Surrender only, yes, Tuhin and Anil surrendered.
Who was arrested?
Arrested Tuhin,
What was the name?
It's
Mahibul Haq
Mahibul.
arrested.
Mahibul Haq was
He was
arrested on.
arrested. He was the typist come witness.
Nice.
Who is this person who has been allowed the bail? There is one other person, Anu.
There are 7 accused persons.
What is his role?
My lord, the allegation is that he brought the papers to the lead writers and to manufacture the documents. His role is defined from paragraph number 2. Of the order he picked up December 2024.
Conspirator.
My lords.
It's just organized crime.
All of them have been in custody now for how long?
45.
Is the investigation is complete?
No, madam, wait.
Because of the
ADS, sir.
ADS has not been arrested. It would.
It's now, say, lordship.
My lords, the allegation against us is
These persons, their statement of offense have been recorded by.
Yes.
we have been taken into police custody.
Whatever interrogation you must have done by now.
My lords, petition number 1 has been taken for 4 days in C. Petition number 2 has been taken for 3 days. Petition number 3 for 3 days, and the last petitioner was not being taken into.
All of them.
It is not the fact that we did not cooperate with the investigating agency.
Keep it in the next.
Lords.
That's great.
The speed of detention will be, it will be magistrate trial.
We can consider it right now, or we can.
I feel that. What is going on?
Item number 12. Item number 13,
Well, item number 30 has hard, it's not well, item so well, it can be not today or Monday. In the meantime, it will be delivered, I think. So little showing 1 or 2 days delivery time.
As paid Monday.
Item number 14.
Something for 1 day.
Item number 15. Item number 16.
Item 16. It will say my star.
Monday.
Independent victim,
Monday.
You have the obligation under the act. You can't say no. You can say, please don't do that. You can say, please don't direct us, but you can't say no.
No, I didn't say no to your lordship. I said no to him. My learned senior creditor should intimate to you.
All right, let it come on Monday.
Monday.
Let's see. That's great.
Intimate.
Item number 17.
I will from that wala. Not practical, not saying this.
All right, Monday as played.
Monday, I will be able to. Monday.
You won't be able to. Then as played next Saturday.
Right. Now there is a person appointed in market.
Next Saturday.
Then make it not to my lord.
Sorry.
Not.
Item number 18. Nineteen.
Lordship, the service of the victim has not been completed, it kindly make it Monday.
Item number 20.
Item number 20.
For item number 20, I'm saying for Monday.
Why then?
My lord, I have already served the victim. My lord, it is yet to be effective. By tomorrow, it will be effective. That is
As played.
Monday. Item number 21.
As played next Saturday.
Item number 22.
In this case, notice has been served. In the case, there is a teenage lava here. My age is 25 and the victim is 17. They married
Item number 23, 22, 23. Item number 24.
My lord, am I audible, my lord? Sorry,
Yes.
my lord, I have come to principal. But in this matter, the lawsuit direct us to submit that all the this orders with regard to this. Am I audible, my lord?
Yes, you are.
My lord, we are submitting that all papers at last occasion, director has to submit the list of the cases where I have been discharged. Some of the cases I got the bail, and some of the cases, my lord, I made acquittal. My junior is there to give the list of all the list with the presentation. Kindly,
Give a copy. Now.
yes, sir. My juniors are there. Kindly give the. Kindly give.
Let him go through, let him take instructions. And then we take it. This is already served.
Yes, sir, this was.
The one that you are filing right now. No, there's some cases were left out.
No, we have served them a copy, and there are some more cases we are giving before the court.
But I just, on the last occasion, I give the 6 cases.
Also, we had asked you to give the details. Today again, you are saying the same.
No, that will serve the content. List of 8 cases.
There are 6 cases, then 14 cases.
There are list of 8 cases which served upon them on the last occasion, when the court had access to, we submitted upon them. But we have certified copies and 15 more cases in which he has been discharged, we got it today.
So therefore, there is additional material you are giving today.
Yes.
So what?
Why serve them?
So have you given the additional material that we are asking you?
Yes, sir.
How can we
Yes, yes.
consider without the copy being served on the state council or the learned examiner? And when you give it today, he must get an opportunity to give the get instructions.
But we have the certified copies of the same.
So let him take instructions.
Oh,
that-
kindly, what my lord is saying, can you try to understand? My lord is serve them.
Yes,
To serve them.
instructions on this. then you-
But kindly take it tomorrow. I'll come in the person will come. But tomorrow I'll come, my lord.
Short date is.
Very short date he's saying, he needs more time.
My lord?
You need more time.
Yes, my lord. Actually, my
Well,
lord.
these are list of my lord, all the records are there. The order sheets are there. They only clarify the authenticity of the order sheets only.
No, two from that is meaning and today is.
Inclusion of the list. So, my lord, I am.
Then kindly fix on Monday, then, man. Kindly fix it on Monday. Kindly fix it. Monday they can, by this time they can take the instruction. Kindly, my lord, kindly.
Has handed over a list of, how many additional cases in this list?
15 cases.
15.
These are 14 cases, 15 cases.
On which he proposes to rely during the course of argument. Stop the learned APP submits that instruction is required with reference to these 15 cases for which a reasonable adjournment is required. We therefore direct the matter to be taken up in the next available session. Yes.
Well, there are 150 cases, the other 2 cases I have given one. I got the bail from this Honorable High Court. Others I got the acquittal. Those are also.
Yes,
My
he
juniors.
instruction on all them, he is saying.
Yes, yes, ma'am. Yes, ma'am. Sorry, man.
Item number 25. Yes. So these case was started initially for participant and 79 and 34 Russian. Earlier prospective application of this petitioner along with other things was rejected on 24 April 2024 by the court in Pennsylvania. Hereafter, Russian. Other two co-equal trustees, their second time anticipatory bail was allowed by the Honorable Court Marshal dated 26/9/2024. Long standing civil dispute.
Next time.
Now 26. Item number 27. Item number 28. 28.
The candidate of the election.
No, we are not today.
Item number 29.
This is a 14A and 14C. I'm the Indian citizen. On the statement of the co-accused, my name stands, but charge sheet has been filed. Charge sheet may, I have annexed the copy of the charge sheet, my lord. There is page number 11 and 12. Indian citizen. 14C will be applicable here. If we agree with the story of the book.
What was seized?
Well, these
Cattle,
Cattle seal. Currency seal.
currency,
Currency.
how much?
Currency is total Nepali currency 9,393 and Bangladeshi taka 704.
So there is no counterfeit.
No counter, not counterfeit.
It's for the state.
And 3,100 Indian rupees. In total 38,197 rupees. So for the FI, below the.
Are you appearing or are you not appearing?
Yes, sir, appearing purpose, brief and citizenship.
You are talking to someone else, we are trying to draw your attention, you are not paying attention.
Such a CDS big with Niloy Chakor.
Tell us so that we are waiting for you.
Page number 13, my lord, and the last
All
one,
the details you are giving appears to be not matching with the report. 3,100
Indian rupee,
Indian currency,
Indian currency.
15041 Nepali currency, you said 9393, that is incorrect. Taka also it is
Sir,
one.
my lord, can you see the right hand side value? Value. Page number 10, value. 15041 Nepali currency, value 9393.
That will not make the NC 9393, NC will remain 150.
Oh, well, sir, I'm moving, sir. I have said the value.
There is no allegation of any counterfeit.
Now, in the chart sheet, there is.
Just
Just go through it.
Chart sheet, there is.
Just sit.
Nine. Page number 9.
In the chart sheet.
no, no counter.
Think the mobile too.
In the mobile, from Bangladesh.
Nepali Taka.
You are at serial 1 or 2, both of you.
No, my lord, one. My lord, I am the.
Indian cash.
In the chart sheet, my name transferred, my lord, in the 3. That is page number 13. Last but one paragraph. Line number 5. Line number 5.
That's the submitted to 14A and 14C minus.
I'm Indian, sir.
He is an Indian citizen.
Indian citizen, taxes submitted 14A, 14C.
He is in jail for how long?
No, I'm. Bangladeshi national is in custody.
Any antecedents?
No. No, that's it.
Foreign national have been apprehended.
Item number 30.
It's anticipatory. He has been arrested. The council submits that he is under instructions not to press this application. The application is dismissed as non.
Item number 31. Item number 32.
And who is for the state?
Three.
Actually, I'm going to.
Not today. Item number 34.
Lordship, 1 day accumulation.
Item number 35.
Yes.
Item number 36.
Lordship, I refuse to follow accumulation.
Yes.
Item number 37.
Not.
Item number 38.
38. Not today.
Item number 39.
I will grant for possible.
Why do you want a short passable in admission?
Connecting advocate, I'm connecting the connecting advocate and we want to wait. Maybe in case if
It has to be a.
this is short also.
Look, admission of appeal. And you are instructing your counsel to take a passover in admission.
No. Admission appeal, but I have to let.
That we were asking her, why do you want a passover? It has to be admitted.
Admission appeal. Lack time, completion lack.
So there is any application also.
No.
So it has to be admitted and trial court records have to be called. Application is, the appeal is admitted. That the trial court records the requisition. Since there is no application for suspension of sentence or bail.
After admission, I have to file the application.
The application will be put.
My action was after admission.
We reserve the liberty of the appellant to move such application. Stop.
Item number 40.
Yes, my lordship. I am the appellant in person in this matter. I am trying to place this matter before the next available circuit bench.
Next, as played by the appellant in person, this before the next available circuit.
Next circuit bench. Item number 41.
My learned senior is appearing on rights.
Yes.
I pay for the petition number.
Who's for the,
Mr. Bikram Ghosh was appearing for IOC on the last occasion.
your appeals?
If your lordship recollects the matter, your lordship was had called upon me to show, my lord, after your lordship had seen the copy of the letter of indemnity and guarantee which was filed by my client by pursuant to a reconstitution of the partnership firm, proprietorship firm. My lord, your lordships, may I say two things?
How you proceed, Mr. Gurudev? I think you are versed to invoking the remedy available to you under the.
Yes. May I indicate two things? Your lordship was of the opinion that since my client was already in possession of the IOC outlet in question.
No, we are first asking you the question that
Yes.
belief has not been declined. It is just a question of the report not exercising its discretionary jurisdiction.
Lordships.
Fact that there is an arbitration clause in the agreement.
Lordships.
And it considered that that is a remedy available to you which you should invoke. Why are you averse to invoking that remedy?
Yes, but there are two things. Why? Firstly, the arbitration clause which exists pertains to another erstwhile the erstwhile owner. The incident happened at a point of time when I was not the dealer. So there is no arbitration clause vis-a-vis.
We are not on facts.
No, I'm not saying. I'm only saying, if there is no arbitration clause in respect of the dispute in question, why should I be forced to submit to the jurisdiction for an arbitration agreement when there is no dispute preceding or subsequent to the arbitration? But the issue is, the arbitration and agreement of arbitration can only be with this.
One is existence of an arbitration clause which is not in dispute. The other is whether the dispute is covered by the arbitration clause or not, that you are trying to make out.
No, with respect, no. I am only saying that the dispute in question, that is the finding of the inspection team in June 2021, was the subject matter of a dispute of another dealer. And when I was not the dealer of IOC at all.
We are saying you are not disputing the fact that your agreement also contains an arbitration clause. What we are trying to say is that the dispute is not covered by this arbitration. Now, whether it is covered or not covered, it can be very well considered.
But in the meantime, what would happen is I lose the IOC outlet for reasons for which I am not at all to be blamed. The law is very well settled, but I am not trouble a lordship with the law. If I am forced to accept a finding which pertains to another erstwhile dealer, then why should I be saddled with the liability of another person when I had no trust with that person?
There is no question of accepting any finding. There is a finding already against you that we have seen. There is a decision to terminate your dealership agreement, that also we have seen. Now, if the question is of remedy, which remedy you should invoke, that is the only issue. The report
the judgment which we had shown before the learned trial court was ABL judgment, and the other judgment which I'd like to show to your lordships. Merely because
limited versus ECGC.
The only limited point was that if there is a violation of the principles of natural justice and the action taken by the respondent authorities is not within the principles of Article 14 and 21, then suddenly the writ court can exercise its jurisdiction irrespective of whether there is an arbitration clause or not.
Therefore, that is what we are trying to understand. The issue is only whether this remedy is available to you or you should be relegated to the remedy.
Yes, your lordships.
Now, we have gone through the judgment. Yesterday, you were placing the judgment. We have seen it also. The agreement clause is not disputed by you, that there is an agreement clause in your agreement. The other aspect is that You may argue that there is no absolute rule that you cannot invoke Article 326 or the court is not precluded, it is a plenary jurisdiction. All these arguments you may submit. But there are broadly four principles based on which the writ court may. It is not a shall.
No, I'm absolutely discretion. Discretion is always vested in the bill.
Its jurisdiction.
Yes.
All those four, therefore you are submitting non-compliance with principles of natural justice and therefore you are submitting 14 and 16.
Manoj,
Calls many disputed questions of fact.
Manoj, with respect, may I say this thing?
Yes.
One letter will dispel all the notion that there is a disputed question of fact. One letter. And Manoj, your lordship is also well aware of the proposition of law. If something can be disposed of without even calling for witness action, which is there in a civil suit or an arbitration, then the writ court ought not to shun its responsibility in disputing coming to a conclusion as to whether such a dispute can be seen from the lens of the documents which have been produced by the parties and relied on by the parties.
Court should not shun its responsibility, that we will have to see. This was that there is a responsibility cost on the writ court, that even if there is a disputed question, then we are obliged and we should not shun our responsibility. This was your submission. Please show us.
But with respect, but I am not saying, I am only saying, let the court in its wisdom, let a court in its wisdom
Yes.
try to find out
Of this,
whether
there is no question of shunning the obligation or duty on the written. It's a rule of discretion to be exercised on sound, well settled principles. How the plenary jurisdiction is to be invoked, in which cases the writ court may, in which cases it should not.
that's it.
That yes.
In that even, my lord, your lordship only takes up two things, my lord.
Yes.
Your lordship has been perhaps been of the opinion, of the view that since my client had given and executed an indemnity bond prior to the date of the incident, so he was well aware of the entire nitty-gritties and whether his agreement as a dealer was there or not. It's not relevant. At least this is what the writ court says in the judgment, and therefore I should go and challenge my challenge before the arbitration agreement. The lordship only takes up one letter. That is at page 254.
Let us first get the dates. Your application for reconstitution, give us the date.
Yes. My application for reconstitution, I'll just give it to your lordships. If your lordship comes at page 241 first.
The document, just give us the dates first.
Okay. This is 20th of June 2020. It is a proposal.
And this is that page?
That is at page 241.
Yes. Then after that,
Then, my lord,
was accepted.
then, my lord, next date is, my lord,
16th October 2020.
16th October 2020.
What is that? What is this date?
243. This is your lordship, my lord. My learned junior will assist your lordship because I am a very bad eye. So I cannot read the documents. This is a letter.
Please let him give the dates. You listen to the dates. Let him give.
Yes.
Yes.
So this is at page 243. 16th October 2003. Last two paragraphs. Then your lordship takes up the in principle approval. And thereafter, my lord. Yes.
24 December 2020.
Then we
Reconstruction proposal.
a reconstruction proposal at page 248. on 24th of December 2020. 2020.
There is a list of dates, detailed list of dates where we can take up all this.
We had submitted a list of dates before the honorable single judge.
But in that even, I have got a list of dates with me in the principal court, but I cannot. I'm not assist your lordship with the list of dates, my lord, right now. In that even, will it be a lordship's pleasure to take it up tomorrow?
Can you please send it so that your junior can take out a PDF and give us?
Yes. I can do it within half an hour, but in
Just
that,
adjourn it not today.
But the short list of dates.
We'll adjourn it not today, but please ensure that all the dates in a correct sequence.
I've got it right now. I can send it by PDA, but maybe it won't be.
Again, we are requesting you that please ensure that it has all the dates relevant.
Yes, I shall do so. I shall do so.
Learned counsel for, let senior counsel for the petition. It's that a list of dates will be provided after due service upon the learned counsel representing the IUC. Let the matter be adjourned common not to do.
Number 42. Number 43. Number 44.
For the respondent.
Item number 45. Item number 46.
For item number 45, I'll put the response.
Item number 47. Item number 48. 49. 50. 51. 52. 53.
Well, actually, take one next.
Next circuit, as stated. Give an appearance.
Item number 54. 55. 56. 57. 58. 59. 60. 61.
What do you want?
I'm praying for injunction, my lord. In this matter.
You have
For
served.
appearing in the
You have
court,
served.
my lord. We have
Application has to be served.
service has been.
You filed an affidavit of service.
We are appearing for the first time, my lord.
So you want to serve.
Yes, my lord.
Let service be effected on the respondent by speed post. An affidavit of service be filed. Stop matter to clear in the dates.
Item number 62.
I take to appeal for the appellant. It's a second appeal for admission. There's no delay here, so.
Yes, we can, yes.
And on the last occasion, this honorable court had considered this, that we were directed to amend the memo of appeal and add two additional grounds. That would be the substantial question of law on which the appeal should be heard.
6 months, there was an urgency. I was in court for 3 months. I can 61 months. Direct copy. But they are making construction. The injunction has been added. Injunction has been refused.
You know 62 is called, still you are making your submissions. Now your junior has paid for next circuit. Whatever it is, when the matter is called, how you start making it higher?
People also examines the judgments passed by the lower courts. It's a matter where the plaintiff sought for a job in the tea garden. The landed court below, both the landed courts below.
He sought a job in the tea garden.
Job in the tea garden
As
in replacement of the earlier person who was an employee. The earlier person who was the employee.
He wanted to inherit.
They wanted to inherit. Our substantial question of law which we
You are for. You are for. You are for.
You are for the appellate.
Appellate means garden or for the.
No. From the person
who was claiming inheritance of the job.
Who was not claiming inheritance, but who was in the job against whom the plaintiff was directed. I was the defendant.
No. So the plaintiff wanted to be in place of the defendant.
Right.
And he wanted another defendant to allow this.
Correct.
So there was no consent between you and the plaintiff.
No. Both the landed courts proceeded on the basis.
So he wanted to dislodge you on which ground?
Dislodge me on the ground that the plaintiff is actually the wife of the deceased employee, and accordingly she is
So you have got the benefit of compassionate appointment kind of a.
No, Miller, not compassionate appointment. It's a private job, Miller.
Obviously,
Yes.
but it is based on compassion that.
Based on compassion, rather Miller.
So the term remains the same.
I just rephrase it, Miller. The substantial question of law which we have raised, that the job in a tea garden of a worker is Miller. Basically, it is called badli job, which is Miller customary in practice, not Miller in strict sense, a compassionate appointment or a job which is inherited by the legal.
There is a concept of
badli. The badli job. It is a customary in practice. The job is offered to any of the family member, even if he is not Miller the class 1 legal heir, but a family member of the deceased employee residing within the garden. The concept is so that the job remains within the garden, it does not go somewhere else from outside. Our case was that this person who has claimed the job, although she claims herself to be the wife, has long Miller left the garden, she was residing somewhere else. So the management of the garden was right in granting the job to me in accordance with the prevailing customs, where a badli job is granted to a family member, to a person who is residing within the garden. So this nature of the job is where the landed courts below has added. This customary practice was not taken note of.
So what is the basis for understanding or appreciating the custom that you are relying upon?
It's the way the customs are proved in a court of law.
That's what we are trying to.
Yes, a long and continuous practice, something which is otherwise not contrary to public policy. All these things were.
Where does this arise? What have you come to the court with to establish this?
This is the substantial question of law which we have raised. Probably,
no, but what did you come to the court with?
This was pleaded in a written statement, but not examined by the court in correct perspective.
So therefore, it was pleaded. You must have got something to corroborate your pleading.
Yes.
So what is that we are trying to understand? Merely by saying the pleading will not suffice.
Yes.
Whether it is a custom, a precedent, or based on some statutory provision, you will have to lead some evidence.
Yes.
To show that this is a practice or precedent. What is that evidence that you have shown?
garden management, who was supposed to Miller depose on this, Miller, they failed to depose anything before the court below establishing Miller
It
authority.
is a case of no evidence against in support of your pleading.
But in fact, it went proceeded ex parte against the thing. I mean, so far as our evidence is
You are
concerned,
required to bring your evidence.
so far as our evidence is concerned, we deposed before the court that it is in accordance with the prevailing norms that the work has been granted to the wife
It
of
is
the
not that.
brother of the deceased.
That cannot be any evidence in support of this claim. That is your claim in the pleading, that is what you say. But you have to establish to the court that yes, this is the practice. These are the ingredients of the practice or precedent. And then if the
Yes.
court has overlooked, then there may be an occasion. Otherwise, if you have failed to produce anything in support of your claim.
In fact, despite pleadings on this regard, the issue was probably not correctly framed even by the lawyers. It's a case of subject to correction or remanding that. Whether this question has to be considered.
What is that which you have brought before the court?
In our memo of appeal Miller, the amended memo of appeal Miller, we have inserted this as a ground that this was not at all considered. If Miller kindly considers the grounds 4A and 4B.
File the amended.
This was partial to Miller direction, partial was honorable not in the last. It was amended by hand Miller, partial to be considered this.
So you have inserted by handwriting.
By handwriting, partial to be granted.
Therefore, there are two things that you were required to establish before the court.
Yes, sir.
Now, as a matter of fact, based on evidence, how have you established these two aspects? One, the prevalence of such a custom or practice. And two, the fact that the plaintiff has relinquished such a claim or by any conduct she has become disentitled to such a claim.
That will borne out from records that the plaintiff has willingly relinquished the job. It is on record.
Where is that? What is the evidence in this?
If Miller kindly takes the records. 33.
What is the date of this document?
It's subsequent sometime in 2014.
And what is the date of death? You are Mukta.
Yes.
In the date of unfortunate demise of your husband.
15 September 2013. The death certificate was not exhibited. It was exhibited exhibit 1. You would find the date of death from the plaintiff itself. But page 30 minute is their deposition. Where they have also admitted that it was foregone voluntary. Page 32 is given by appointment letter. You are put it is an endorsement, resignation is substitute for Mary Soren, which who is the plaintiff.
the written complaint of 18/5/2014 and Salishi Sabha held on 23/5/14. Are these two documents exhibited?
FIRs have been exhibited, it's at page 34 and 35. It's annex page 34 and 35.
That is
This
18/5.
was not exhibited.
Oh,
The page 29 is the list of exhibits.
why didn't you exhibit this?
They were relying on this, that they have been illegally pressurized to sign the resignation, etc. That was their case. You will find the list of exhibits at page 29.
Well, you are the elder sister.
I am the sister of the deceased. Elder sister of the deceased.
No, elder sister of the wife of the deceased.
Wife of the deceased, that's right, I'm sorry. Wife of the deceased.
So the trial court, what has it done?
Let us,
Accepted the claim of the plaintiff.
yes,
And the appellate court has also accepted the claim.
also accepted the case of plaintiff on the line of inheritance.
It's not a claim by inheritance.
Absolutely, that's what our case is.
She is also not claiming by inheritance. She says that she was granted this job, but she was
Pressurized to.
pressurized, beaten
Pressurized to beaten up
to
to.
sign a blank paper. Based
Yes.
on that blank paper, this
Yes.
application that you are relying upon, that is her case,
Yes.
has been drawn up and she has been ousted. In her case, you have come in and you have misappropriated all the provident fund amount in collusion with the manager
Yes.
of the team.
That is however incorrect.
That is the her
because-
case.
Because as a matter of fact, all benefits to which her husband was entitled to has been taken away by her. So we have not gained anything which was pertains to his dues or statutory payments.
Now it is only a question of this job.
Only a question on this job. And would find.
In the relief, did she claim anything apart from the job or the PF proceeds also?
If Miller takes the claim, it's only a declaration that
Get
you actually
any
are not
benefit.
entitled to get
Any benefit, not
Yes.
only the job
benefit,
and
financial.
all financial benefits. So
And
she was
C
claiming.
is the prayer for the job.
Yes, so it is everything. It is not just for the job. And what is the decree?
Yes. You would find that the plaintiff and her daughter are entitled to get all financial benefits of deceased Samuel Soda. So we are not disputing that because according to us, no benefits have been enjoyed or taken away by this by the appellant before your lordships. So the only question survives.
No, but the decree is against you.
Yes, yes.
What do you mean not disputed?
But
The
today,
decree is against you.
yes, but today we are not
She
agreed
says,
by that part.
he says that she has been, the benefits of her husband have been misappropriated by you along with the manager of the state.
Correct.
And that has been accepted by the court and a decree has been passed.
Right.
So you are right now a judgment debtor.
Yes, but we are not agreed by that part because according to us, if any claim lies, that could be against the guardian because we are not.
That you cannot say. Once the decree has been passed against you, that does not lie in your mouth to say that it will be recovered from the tea estate. Because she says you in collusion have already taken it from the.
But that has not been proved.
But the
No
decree
amount
is
has
there.
been quantified.
The decree is there.
Decree says.
Quantification may be done.
Kindly see, it's a prohibited, it's a declaratory decree only. That's the plaintiff number
Where is
one
the-
is entitled to get all the
Can you
financial.
show us the which page number it is?
It's in the memo of appeal, the last page of the landed lower court's judgment. The last page, the ordering portion. So it's merely a declaration. Had it been a specific claim for misappropriation, the amount ought to have been quantified and the money decree, it would have attained the color of a money decree. Look at the plaintiff's own deposition, Millard, it would appear that she has voluntarily consented to leaving Goa. Her own deposition, which had already.
No, that was not a petition. That is a letter allegedly written by.
No, the affidavit in chief.
No, you have not placed the affidavit in chief. You have placed that letter. Which she says most probably it will be her case. It will be her case that you have drawn it up on the blank paper that you have taken from her under duress.
Yes, Millard, I placed page 30 and 31, Millard, which is the deposition of the DW1, that is my client, the applicant. 30-31 of the stay application, Millard, para 11.
You said that she has admitted in her deposition.
No, my client has said, but that has
Our
not been,
clients
that has
will
not been
always-
controverted.
Client will
Millard, can you
always
see the cross examination?
client
Nothing
will always-
forthcoming, Millard, which can shake this statement.
Client will say that it's not an admission. That cannot be
Millard,
taken as an admission.
this document.
He is already employed now.
Yes. I was under employment, Millard, my name has been shadowed. Serving for 10 years, I have been hosted. Because I am there since 2013.
You served because the matter was pending.
That's right. Well,
Not
the
because
plain-
she allowed you to serve for 10 years on the case.
Yes, but Millard, the
Served
plain-
because the application, the complaint was pending and then appeal was pending.
the plaintiff was preferred, Millard, in
Therefore, that
2016.
does not create any, request any right in your favor. That 10 years is during currency of the proceedings.
Plaintiff was preferred in 2016.
Therefore, that will not waste any right in your favor. We don't find any admissions, like you said.
Millard, if you will kindly consider this, Millard, that voluntary relinquishment, Millard, has not been dealt with appropriately.
Let us,
There was, Millard,
Let us-
evidences
let
on
us-
record, because Millard could find,
there is only one document which you rely upon
yes,
in support of the relinquishment.
in support of the
And
relinquishment.
that also you
Millard, the
say,
appointment letter.
that also you say is not an exhibit. So it is a case of no evidence in support of this fact.
This was not exhibited.
Then what else? There is no other evidence.
Because the difficulty was, Millard,
The difficulty may be anything. The fact remains that it was not an exhibit.
Millard, the fact remains, Millard, that these documents were all part of, Millard, the documents pertaining to the records of the garden. We have been given photocopies of this, but the garden never appeared before the court.
There is sufficient provision in the CPC for.
Millard, how it
Don't
went,
say that.
Millard, how it went, Millard, can.
We don't know. All that, if you fail to take appropriate steps, then who is to suffer for that? Not the other side.
So that at least, Millard, that opportunity, Millard, may kindly be granted so that these things can be at least,
She will
Millard,
think she has gone through enough.
at least this can be, Millard,
There is no material whatsoever. It's just a plain, you say that this is the condition.
no, Millard, in the
In
written
your
statement,
written statement, you
written
say,
statement where this has been.
where is your
categorically
WS?
stated.
Where is your
Yes.
WS?
Millard, can you take, Millard, my stay application, Millard, page 20. Para 10 onwards.
This is your WS.
Give the written statement.
Just allow us to go through it.
Yes, Millard.
Where have you stated about this letter that you are relying? Where have you stated the date of this letter that you are relying upon? 17 of
Para 10 million, we have stated that the plaintiff number one willfully declared for getting job to Mukteswaran, defendant number 6, before witness in local public and also manager, those Chandra.
Therefore, we are asking you, where have you said about this letter?
No, this letter was not relied upon.
Not relied upon you by you. And a vague allegation made in the WS without reference to any date or any detail whatsoever.
That these documents were subsequently at the evidence level, this was tendered, but could not be exhibited for due to absence of the guardian manager. Tender also.
Nothing, no evidence whatsoever. Apart from this one sentence in paragraph 10.
Can I just get one day standard to just inquire from the.
What will he inquire, whatever is there, it has,
What were the documents?
now
which
it
were-
has to be confined to the records of the case.
No, that the entire record probably is not before your lordship. You are only the list of exhibits, what were the documents, whether at all anything was exhibited.
The list of exhibits must be here. It is there in the trial court's order itself.
It's only the list of.
There are
exhibits by
3
the
exhibits,
20.
4 exhibits,
6 exhibits.
4 exhibits.
Four exhibits, 2 was tendered, not exhibited.
Yes, these are, it's marked X and Y, these are not exhibits.
Yes.
And even in these 2, this document is not included.
This a copy of agreement I can find. This was marked for identification subsequently since the garden.
But that agreement that was marked only for identification is of 23/5/14.
Yes.
This is not this letter. This letter is of 17/10/14.
The 17/10/14 is the endorsement that is received by the garden, but the date I could not find.
This is the only date by which it can be identified. By no stretch of imagination, it can be of 23/5/14.
Accept. 17/10/2014.
These documents are there, 23/5/14.
23/5/14 is there.
In your file, where is this?
This was relied upon by.
Where is it? 23.
No, it's not there. It's not in our possession. This is a copy of the agreement. May just have a look at the document just one day time. If I can find anything by also supplementary.
No supplementary effort. Whatever is there on record.
If I find something, I can make a prayer before
If
lordship.
you make a prayer, then we will consider. As prayed, I will not counsel for the appeal. List on the date of Monday. And we are. Yes, what do you want?
But I'm a declaration injunction. Publication. But my prayer for injunction was beautiful.
The other side, we don't know if somebody is.
There is no packet one. It's again for the first time.
We don't know.
Then
Somebody,
can you text it tomorrow?
maybe somebody is watching letters,
So can you text it?
not today.
1600 October. 1600 October.
Attendance 63. 54.
Lordship, may I seek an indulgence, Lordship? Lordship, item number 59, Lordship. I'm extremely sorry I missed that out, Lordship.
64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75.
That's great.
Lordship, item number 59, Lordship, I'm praying for 1 day of accommodation, Lordship. If it
76,
may kindly be possible.
77,
My lord, 77, my lord, I am appearing on behalf of the
79, 80, 81, 82, 83, 84, 85,
Worship, I have got respondent number 2.
Not today.
86, 87, 88, 89,
Which I am for the respondent.
89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104.
And I think not 90, 98, 99. I got that and pay for next circuit already.
That's great.
98,
99.
98, 99,
My lord, item number 68, I am for the petitioner, my lord.
99. Next circuit.
I am paying for next circuit, my lord.
103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 14, 15, 16, 17, 118, 119, 120, 121, 22, 23, 24, 25, 26, 27, 128, 129, 130, 131, 32, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144. 59.
Lordship, item 59, I'm praying for 1 day accommodation, Lordship. Kindly fixes it tomorrow, Lordship.
My lord, item number 68, my lord, I am for the petitioner, my lord. I am paying for next circuit, my lord.
58. As you give, I have to send someone with an appearance.
Grateful, lord.
Next circuit. NCB.